So I'm going to introduce the moderator of our next session. And this session is on an incredibly important issue. And I think everybody knows, and in reporting around the spending and politicking around judicial campaigns shows that criminal justice issues just get brought into all of it in the hardest way. And this session is about lives on the line, fair courts, and criminal justice reform. A sponsor of our summit, so we very much appreciate this, one of the sponsors is the American Constitution Society, and here to moderate this session is Caroline Fredrickson, who is the president of ACS. She's been the president since 2009, and ACS does a tremendous amount of important work, research, network building, visibility work, so many different kinds of things that it's really amazing. We're grateful to have you here, Caroline, and I'll just turn the session over to you. Thanks so much.
Well, thanks, Liz. And I just want to thank Justice at Stake for being such a great partner. And I particularly want to just say thank you to Bert for being such a great leader for the organization, for the movement as a whole, and being a friend of mine and a friend of ACS, and leaving Justice at Stake in the very, very capable hands of Liz Seaton. So I just wanted to thank you for that. And just to say a little bit about this topic, in criminal justice is obviously an incredibly important part of our justice system. But one of the aspects that we at ACS had wanted to lift up as we engaged with Professor Shepard on her research was that criminal justice is just one piece of this, but we're trying to explain to people who care deeply about a variety of issues from criminal justice, but also to including reproductive rights and the environment and everything else that people sort of get excited about, that we need to be able to translate that into a passion about the state courts, because so many of those issues live and die in that arena. And so one of the reasons that we had focused on criminal justice was because it is an area where we've had a great amount of attention over a long period of time, but particularly in the last year, a big spotlight on the inadequacies of our criminal justice system. And we wanted to focus on the way that the judicial system can be affected by money, as our electoral system has been affected in the case of legislative actors. And so now I want to just introduce our fabulous panelists who are going to bring that criminal justice focus before you. It's an incredibly important topic. They've all done phenomenal work in this area. And I'm going to start by introducing Randy Susskind, who is in the middle. Randy is the Deputy Director of the Equal Justice Initiative in Montgomery, Alabama. He's been an attorney with the Equal Justice Initiative since graduating from Georgetown University Law Center in 1994. And he serves as an adjunct faculty in the Equal Justice and Capital Defender Clinic at the New York University School of Law. So obviously spends a lot of time on airplanes. And Joanna Shepard, who I know spends a lot of time on airplanes because she comes and does all sorts of wonderful presentations for ACS, teaches torts, law and economics, analytical methods for lawyers, statistics for lawyers. Do lawyers actually take statistics? And legal and economic issues in health policy at Emory Law School. Before joining Emory, Professor Shepard was an assistant professor of economics at Clemson University. And in addition to co-authoring the report Skewed Justice, which she did as an ACS project, and she will talk about skewed justice today. She also wrote, as a collaboration with ACS, Justice at Risk, an empirical analysis of campaign contributions and judicial decisions, a study that revealed the growing relationship between money and how state Supreme Court justices rule in business-related matters. And last, but of course not least, we have Judge Arthur L. Hunter. Judge Hunter was elected in 1996 to the Orleans Parish Criminal District Court in New Orleans, Louisiana. He currently serves as the presiding judge of the Orleans It sounds funny saying it without New Orleans. It's like, sounds like I'm talking about Cape Cod, for those of you who know Orleans and Cape Cod. Reentry Court and Veterans Treatment Court. He's best known for noticing that more than 1,000 defendants had been kept in jail for 9 months after Hurricane Katrina without access to lawyers, moving to let some of the defendants without lawyers out of jail, suspending prosecutions in most cases involving public defenders, and granting a petition to free a prisoner facing serious charges without counsel. He works to improve the public defense system in Louisiana as well as to reduce mass incarceration, and continues to do so today. And I think he is well known in this community for that very important work. So I want to thank you, Judge Hunter, and thank the panelists for being with us today. Randy, I'm going to start with you. And each of our speakers is going to give a bit of a background in this opening section. But you have had judicial elections in your sights and the impact on criminal justice for some time. Can you talk a little bit about the report that you issued in 2008 on this matter and sort of what your follow-up has been?
Sure. Thank you for the introduction. Our organization, Equal Justice Initiative, we've been around since the early 90s, and among other projects and initiatives that we have is a death penalty project where we represent people on death row in Alabama. Alabama has the highest death sentencing rate in the country. It's about 200 people on death row, and there's not a statewide public defender, and so we feel responsible for a lot of the guys on death row, almost all of them in one capacity or another. And over the years, when you're representing individual clients and also advocating for a broader issue like the death penalty, and you're dealing with people who are despised and unpopular, you look to the courts to help. It's not, in a place like Alabama, there's not really a legislative strategy for abolishing the death penalty or reining the death penalty in. And so we've always been looking at the courts as the place where the Constitution can be enforced and our clients can be protected. Unlike other issue areas, and some of the issues that we work on are different as well, there is no constituency for people who have been accused of horrible crimes. There's not a group of people in America who are fighting to protect defendants who are accused of rape or murder. And because of that, we really had no other option but to think we have to go into the court, we have to look at the judges, we have to look at the appellate courts and hope that they can help protect both the Constitution and our clients. And so we're coming at this from a perspective of we don't really have a grassroots group of people. We can talk to coalitions and people who are interested in this issue from an academic perspective or from a social change perspective, but there is no group of people who are aligned with us because most of our clients are in jail and can't vote. So looking to the courts, it became very clear with the death penalty that it was difficult to get a fair shake in the courts for a whole bunch of reasons. I mean, we all know about the race bias and the poverty bias and the lack of representation. But what became clear was that judicial elections and judicial selection was driving a lot of the problems. What was interesting over time, and if you look at look at anecdotally United States Supreme Court justices, either after they're off the bench and they're writing a book, or it feels to me like the day they're retiring, after 10, 20, 30 years of believing in the death penalty, their parting shot from the court is, I now don't believe in the death penalty. I shall no longer tinker with the machinery of death. My one regret was the vote in Furman v. Georgia that said that the death penalty is constitutional. If I had voted a different way, we wouldn't have the death penalty in America. And what, as an advocate, trying to rein in the death penalty or have the death penalty abolished, on a broad level, it felt as if we were actually winning if you take these justices at their word, that what we were doing was actually working in terms of persuading people who were in power to think about this in the right way. On an anecdotal level, countless times I've been in court in front of judges who have sentenced my clients to death. We are on an appellate posture, coming in, complaining about the case or complaining about the lawyers in the case, and making a presentation about why our clients shouldn't be on death row. And I cannot tell you how many times judges have said to me, that was interesting, your guy probably shouldn't be on death row. But, sort of shrug your shoulder kind of thing. And again, it did feel like over time, at some level, in terms of massaging the law and investigating the facts and making our presentation and spending all this effort trying to persuade people, that we actually were both completely succeeding in that on a personal level, people were being touched by what we were saying and persuaded by the arguments. But on a practical level, nothing was happening, and that there was something else out there that was preventing us from winning. And that's what initially led us in the early 2000s to start looking at basically the issue of fair courts and trying to figure out what was happening. And that led, it was pretty clear early on. In Alabama, there was early on a lot of money being thrown around with judicial elections between the plaintiffs' lobby and the corporate defense lobby. And all of that we were not involved in, except that the way that the money was being spent was to provide funding for people who are running for office for judicial positions, and they would basically go after criminal justice issues as a way of advancing their political career, attacking their opponents. Professor Shepard's report documents this both anecdotally, but also with the data that just absolutely proves beyond question that people are influenced by these attack ads. And so I think just initially our approach was something has to be going on here that is preventing us from both winning at sort of a personal level, but basically losing almost in every arena, in every judicial arena, and that was basically the issue of fair courts. I wanted to, and a lot of this wasn't even hidden. You would go to a CLE conference, you'd be on rules committees, you'd be in court with judges, and none of this was a secret. The judges would say, well, we can't rule that way, because if we ruled that way, we'd have to reverse 10 cases a year, and what that would mean, kind of, nothing related to the law or the process of legal decision making. It was basically like, we all know that we're elected judges, and we all know we can't there's a cap on what we can do for criminal defendants, or we're going to potentially not be able to keep our job. And so this was something that we felt a need to document, instead of basically saying, these judges are telling us that elections influencing them, to try to really get underneath the data and try to figure out what's going on. The other thing that was happening was, in addition to just pure money politics, there was the grassroots campaigning, particularly from the religious right, where it wasn't necessarily about money, but it was definitely about influencing judicial elections. And for us, again, folks who were interested in influencing judicial elections for purposes of their own moral persuasion or their own religious issues that didn't necessarily have anything to do with criminal justice issues, we saw again that our clients and the crimes that they were accused of were becoming the centerpieces for judicial elections that were about something else. But in terms of exploiting the facts and exploiting our clients for people's personal gain, the grassroots movement that were more concerned about other issues like abortion or gay marriage or something like that, they were using the crimes of our clients to advance their own agenda. I just wanted to read, it's in the materials that I submitted, but an associate justice on our court has been on the court for a long time, Justice Tom Parker, and the case, there was a United States Supreme Court ruled that juveniles can't be executed, and one of the cases that Justice Parker worked on when he was a prosecutor was one of our clients. And our client was sentenced to death. He was 17 years old at the time of the crime. And by virtue of the Supreme Court case of Roper, he was ineligible for the death penalty. His case went to the Alabama Supreme Court. And by that time, Justice Parker was on the court. He recused himself appropriately, but he wrote an opinion piece in the Montgomery Advertiser, the local paper. And if I can just quote from it, I think it really informs the way we think about how grassroots campaigning taints the judicial system in a way that we feel like we want to confront. He wrote that his fellow justices chose to, quote, passively accommodate rather than actively resist an opinion from the United States Supreme Court. He, did all the political stuff by calling the Supreme Court's reasoning, quote, ridiculous. He invoked the word accomplice in reference to his fellow justices, but in the same sentence where he was talking about the crime of our client, where it felt like he was accusing his fellow justices of being accomplices to capital murder. And he basically said the only real thing we should do is refuse to follow United States Supreme Court precedent. We should actively resist it. And I just want to quote from the final part of his piece because it really highlights for us how the criminal justice issue, he clearly is not motivated by capital murder and who gets a death penalty, who doesn't. He's motivated about some broader agenda, and he's using our clients and our issue as a way to influence others because it's so inflammatory. He ended his op-ed piece by saying, after all, the liberals on the United States Supreme Court already looked down on the pro-family policies, Southern heritage, evangelical Christianity, and other blessings of our great state. Conservative judges are on the front lines of the war against political correctness and judicial tyranny, and they should not surrender. And again, on top of the money in politics, we were seeing that because judges are elected and because they're so politicized and because judges are able to posture like this, that our clients and our issue is being affected, even though we really had nothing to do with evangelical Christianity and the issues that they were dealing with in Alabama. And so that was our general approach and why we felt a need to, and why we came to realize that fair courts is both an issue just like race bias and arbitrariness and poverty, but it's also tied into everything.
Well, thanks so much. And it's a very helpful, I think, segue into what I want to ask you, Joanna. So Randy's referenced your fabulous report already, Skewed Justice. If you haven't all grabbed a copy, you should. It really reinforces everything that Randy has said about the role of attack ads and so forth. It's this really hard data showing the truth of what you talk about. So Joanna, can you talk us through what the report says and sort of and how the data has been used, and how do you see those numbers?
Sure, absolutely. I'm actually going to present some slides. Just anytime I'm talking about data, I think it's easier to have pictures instead of talk through numbers. Skewed Justice, first of all, thank you, Justice at Stake, for having me here today. Thank you to ACS for the continued support of my research. Skewed Justice focuses on the influence that money in judicial elections has had on the criminal justice system. Previous projects that I've done have looked at the influence of money on other kinds of decisions, but this one specifically focused on criminal appellate decisions. We focus on this issue in state courts specifically. State courts handle about 90% of the judicial business in the US, but in criminal cases, they're even more important. About 95% of felony convictions are happening in the state courts. This picture above you gives, above me I guess, gives kind of a map of the different selection methods that that the different states use. So there's some state judges that are appointed by the governor, some by the legislature. There's partisan elections, there's nonpartisan elections, there's retention elections. There's a bunch of different methods that different states use. But importantly, about 90% of state appellate judges have to face the voters in some sort of re-election. And so that's where there's a lot of influence. There's the possibility that money can really influence the outcomes of these elections and in turn influence the way cases are decided. Let's see, what's next? So the selection methods in the states has been rather stable over time. We've seen a few little changes here and there. You know, there's been a lot of movement towards changing at least kind of the partisan election systems to something more nonpartisan, but in general they've been pretty stable. What we have seen is a large increase in the amount of money that's involved in these elections. Beginning in the 1990s, prior to 1990, most judicial elections were kind of sleepy affairs. They were judges often ran uncontested. TV ads were unheard of. There was very little campaign spending. But beginning in the 1990s and then accelerating dramatically since then, judicial elections have become much more competitive, and the amount of spending in these elections has just skyrocketed. So for example, in the 1990 elections, all of the state Supreme Court candidates around the country raised about $6 million, a little bit less than $6 million, whereas in the last 4 of the last 7 election cycles, Supreme Court candidates have raised more than $45 million. And so we've seen that's about an 8-fold increase in about 15 years. As notable as the expansion in money is the way in which the money is being raised. So increasingly, we see campaign money flowing not directly to the candidates, but to independent groups who are not directly related to any of the campaigns, even though they may oppose a specific candidate or support a specific candidate. In 2002, there was $2.7 million that went to independent spending, independent groups, whereas in the 2012 election cycle, there was over $24 million. And so that's, again, kind of like a 12-fold increase over about 10 years. In fact, the biggest spenders in today's campaigns are giving more to independent groups than they are directly to the candidates themselves. So the reason why this is important is because of the way that the money is spent by independent groups. We see a lot more of the independent group money going towards TV ads. There were, as I said, almost no TV ads ran in the 1990s, whereas in 2012, the last data where we have kind of the compiled data for, there was over $33 million spent on TV campaign ads just for Supreme Court candidates. And so we've really seen a skyrocketing of the number of TV ads. In addition, we see a lot more harsh kind of attack ads, what they're typically called, from independent groups. This shows the TV, kind of the tone of TV ads when the TV ads are ran by the candidates, by the political parties, and by the interest groups. And there's just a lot less accountability when it's coming from an independent group. They're not so concerned about maintaining some sort of, temperament that suggests that a candidate is worthy of office or something like that. And so we see a lot more attack ads run by these groups. And the biggest issue that's often the subject of these attack ads is criminal justice issues. And so in a second, I'm going to play some TV ads to give you an example. But these are the issues that really motivate the voters. The voters don't care in general about tort reform or contract law or all the other boring things that I get to teach in my classes, but they do care about criminal justice issues. And unfortunately, what judges will see is that their decision in one case can become fodder for a future TV attack ad, and obviously the facts are not all given. They just kind of lay it out there bare bone. This guy at one point supported one rapist, and they forget to tell you that there was an unconstitutional search and whatever, the reason why the judge overturned the conviction. And so it really is kind of these TV ads potentially have a very important role in influencing who wins elections and then influencing how those judges are going to vote once they're on the bench. So we're going to play a couple of examples of some of these attack ads, just because some of you in states that don't have these will be kind of shocked at the tone of these ads.
Johnson, Kelly, McCormick. Tough on crime? Hardly. Johnson, Kelly, McCormick have the wrong priorities to protect Michigan families. Johnson has a record of questionable judgment, putting communities at risk. McCormick volunteered to represent terrorists at Guantanamo Bay and fought to protect sexual predators. And Kelly is a former appointee of scandal-ridden Wayne County Executive Bob Ficano. Tell Johnson, Kelly, and McCormick that Michigan families need judges to protect them, not criminals. When crime occurs, victims deserve justice. But as a judge, Bill O'Neill expressed sympathy for rapists. Justice Robert Cupp will protect victims of violent crime. Please endorse, highly recommended. Re-elect Robert Cupp to the Ohio Supreme Court.
As a former police officer, Sharon Kennedy knows that safe streets strengthen small businesses and our neighborhoods. And as judge, Sharon Kennedy upholds the law with integrity. Sharon Kennedy, our best choice for Ohio Supreme Court.
A priest sexually abuses children for 30 years across Wisconsin. A mother tells DA David Prosser her 2 young sons were sexually assaulted. What does Prosser do? Prosser refuses to prosecute, doesn't even ask the police to investigate. Instead, Prosser meets with the bishop. To avoid scandal, they send the priest to another community and the assaults continue. Tell David Prosser, judges should protect our children, not sex offenders.
So these are pretty standard. I mean, over and over again, we see commercials where they claim that a judge fought to protect sexual predators, Judge so-and-so is sympathetic to rapists, Justice Robin Hudson is not tough on child molesters, not fair on victims, tell David Prosser judges should protect our children, not sex offenders. And so the list goes on and on. It typically involves some sort of, wonderfully heinous case that the voters feel like they can get behind. And so, the problem is that judges will admit that when they are voting in a lot of these cases, they do think about, in 4 years during their next election campaign, how is my vote in this case going to be used against me? The voters obviously won't understand that there were constitutional issues or procedural issues or whatever. The voters only know that at some point, this judge, voted to overturn the conviction of a rapist or a child molester or a murderer or something like that. So to explore the relationship, this is a map of the number of states. There's 23 states that have aired these attack ads in these state judicial campaigns. So to explore the relationship between independent spending and TV ads on judges voting in criminal justice cases, I worked with a team of researchers. We collected data on 3,100 cases, criminal cases, in 32 state courts. We were looking at judges' decisions in murder cases, rape cases, robbery cases, and violent aggravated assault cases. We had data on over 470 justices' votes in these cases. And then we merged this data with the Brennan Center's data from the buying time. I believe there's a little info in that in the little red bags that you have. The Buying Time Project at the Brennan Center has collected data on all of these TV campaign ads. So during your lunch break, if you're looking for something to do, you can actually go click through a bunch of these commercials and see them. We also collected data on the judges' careers, when their last election was, when their next election was, data on the state's judicial system, specifics of, each state's a little bit different. And we ended up with quite a few data, over 470 judges' votes in 3,100 cases, so a very large data set. What we found is that, and this doesn't mean a lot to you, but in general, the more TV ads that were aired, the less likely a judge was to vote for a criminal defendant. So we found this both across states and over time. And we found that as the number of TV ads aired in a state, and especially over time, the judges became less and less likely to vote for the criminal defendants. We also looked at the effect of the independent spending unleashed by Citizens United. So Citizens United said that these bans on corporate and union expenditures and these kinds of elections going to independent groups were unconstitutional. And so we've seen a huge increase in the amount of money coming into these elections, specifically the money going to independent groups who typically are running these harsh attack ads. And we were able to use kind of an interesting experiment that Citizens United provided. There were only 23 states that had the bans that were struck down by Citizens United. So what we were able to do was look at and compare those 23 states and what happened there versus what happened in the other 27 states where Citizens United didn't have a direct influence on that part, the independent spending. And we found that in the 23 states where the bans were declared unconstitutional, we see a huge increase in money, and we see a 7% drop in judges' likelihood of voting for criminal defendants. So in some are now, and I'm happy to answer more specific questions. I could go on and on about the data in a way that you wouldn't want me to, but in general, what we found is that the TV ads and the independent spending money is having this negative effect on judges voting in these criminal cases. And importantly, we find that the effect grows larger the more TV ads that are airing and the more independent spending there is. And so we're seeing this trend. After Citizens United, we've now had 2 election cycles, and we're seeing increases in the money, which only suggests that the effects will grow larger, and we'll see more and more impacts on judges' decisions in these cases.
Oh, well, that's troubling, to say the least. Thank you, Joanna. So Judge Hunter, sort of picking up on this theme, you have been a real leader on the judiciary of looking at issues of overcriminalization and mass incarceration. And I'd love to hear you talk a little bit about what you think courts can do in this area, and then to link back to Randy and Joanna, how has the sort of the electoral process for judges influenced that particular development of, when I mean overcriminalization and mass incarceration, that linkage?
It's tough being a criminal court judge. I'm going to start out with three names for you. 5 years ago, Troy Beckton was arrested for selling heroin. Terrence Ramey was arrested for possession of heroin. Stephen Tate was arrested for burglary. Today, Troy Beckton is a welder who runs his father's welding business. Terrence Ramey was a welder offshore whose company trained him to be a crane operator. Stephen Tate, even though he had some serious health issues, is now works for an air conditioning company. He's now HVAC certified. So about approximately 5 years ago today, we started a reentry program. And after doing some research on reentry around the country, I found that reentry normally starts when a person is placed on probation or is released, or after he's released from prison. We decided to take a different tact. We sentenced nonviolent felony offenders to Angola State Prison for a minimum of 5 years, a maximum of 10 years. During their stay there, they are trained in skilled professions: carpentry, HVAC, welding, culinary, heavy equipment, electrical, and those skilled trades. And they also have to obtain a GED as well. But they also undergo soft skills preparation as well: money management, anger management, victimology, and really getting the right attitude once you get released. And what's also unique about our program as well is that the trainers are actual lifers at Angola. These guys who have committed murder for the most part. So they do the training. Well, they also have soft skills mentors as well, who are also lifers. So this is where the training is coming from, these guys here. Once they complete the program, they are then released to Judge White, Lori White, and I, and we monitor them on a monthly basis. And they also have their own probation officer as well. And we started this program knowing that in Louisiana, at one point had the highest incarceration rate in the world. And of course, the United States has the highest in the world as well. And so the recidivism rate in Louisiana for the first 5 years was 50%. Our recidivism rate now is we have a 70% successful completion rate. And it really gets to the point of, as a judge, especially those judges who preside over specialty courts, I think we've taken the extra step in judging to believe and to feel that there's more to being a judge than just sentencing someone or just wearing that black dress and making decisions. I think what we try to do is improve the quality of life in our communities. Because the guys that we sentence, and the gals who we sentence to jail, 97% of them will be released. 97% will be released. And so the question is, how do you want them released? Do you want them to just go to jail, watch TV, and do nothing? Or do you want them to be what it used to be, rehabilitated? That used to be the mantra in the 70s. It's a rehabilitator. And so that's the tactic we've taken, is to give them the skills, the educational requirements, and a job waiting for them once they're released. so that they would, again, improve the quality of life in our communities, but also have that personal responsibility as well. Because once they are straight with themselves and have the right attitude, then their children will see that as well. Their wives, their girlfriends, their family members will see that as well. And hopefully, they will become role models in the community in which the other ones who are not doing what you're supposed to do can see that as well. Because I think that's one of the problems that's out there, is that there's no one to positively imitate in a lot of families in New Orleans, or really across the country. And so that's what the heart of the program is making sure that when they are released, that they can contribute to the community. We are looking to expand it to women. As a matter of fact, we have a reentry summit coming up in August, in which we are going to brainstorm how we bring reentry to women, because the women have the children, and one of the problems we run into is because we teach hard skills, the plumbing, electrical, carpentry, and not too women are really interested in those skills. So we need to also identify a skill set that we can have there as well. And I hope I'm not sounding sexist about that. I would love to see women plumbers and women carpenters and what have you, but not everyone wants to choose that tack. So we're going to brainstorm and make sure that we bring it to the women's prison in Louisiana as well. And basically, that's the program. And we have employers, for the most part, who love the program. They love the program. The problem is that the follow-up is not there, because it's easier to talk the talk than to walk the walk. Many companies just don't want to hire ex-offenders. But like I try to tell them, they're going to be released. They're going to be released. And how do you want them released? And not only that, for taxpayers, do you want more bang for your buck by teaching them the certified skills, making sure they get a GED, making sure their attitude is right once they get released, and reducing their recidivism rate, and reducing crime, and so, some people accuse us of being policymakers. Some say we're social workers. I say we're reducing crime, we're preventing crime. I say we're smart on crime. I say it's smart justice.
Well, thank you, Judge Hunter. It's really admirable, and I think we wish more judges and more states had programs like that. But I want to follow up on what you said at the end, which was some people think we're policymakers and some people think we're social workers. And in particular, to sort of get back to the issue of elections, I think you have partisan elections.
Yes.
In Louisiana. So can you talk a little bit about whether either the way you've administered this program or more generally the possibility of attack ads in criminal justice matters has had an influence on you, or whether it's an anxiety, or whether you've seen other judges be so influenced?
Well, believe it or not, when you're campaigning for re-election, the public likes the fact that you're now starting programs to help people. Now you have you have so many Republican candidates running now. They are talking about criminal justice reform, the mass incarceration rate. I mean, this was not part of the election cycle, 6 years ago, 8 years ago. It wasn't there. So everybody's talking about it. The question is, what are they going to do about it? So I think that the trend has changed from being tough on crime, because we've shown we are tough on crime. We have some 2 million people in jail, more than China and more than Russia. So we've been tough on crime. But crime is still there. It's still there. And so I think people want something else. And like I tell conservatives, I say, look, I was a former New Orleans police officer. Judge White, who's founded the program with me, was a former prosecutor. So we're not doing this out being bleeding heart liberals. This is about just making sense and doing something that we believe that's sensible, that's smart, that offers a solution to the large incarceration rate that we have in this country. I truly believe that if we're going to send people to jail, then they need to be given the skills and basically a GED, so that when they release, they don't go back to what they were doing before. And hopefully, they will be role models within their families and within their communities as well, and as much as possible in that cycle of crime in those certain communities.
So I just want to mention for a minute before we go on that we're going to open up to questions in just shortly, but you have note cards on your table, and I wish for those of you who have questions, you'd write them down and say which panel member you'd like to direct them to. Randy, picking up on what Judge Hunter has said, there's obviously, some judges are standing up, doing the right thing, resistant to the pressures of attack ads, and are willing to look for justice in the criminal justice system. Do you feel like your study has helped in Alabama? Have you seen any progress? And if not, what is the next step for you?
I don't know about whether the study has helped. I think from our perspective, using personal sort of narrative stories of individual cases using that as a lens to get at how politics and the courts is a problem. And so, for example, we had recently one of our long-term clients who's been on death row, and he's innocent, was just released. He was on death row for 30 years, and eventually the prosecutors were forced to admit that they didn't have the forensic evidence that they had used at trial, and that it was flawed, and our client was innocent, and he was released, and the media wants a villain, and they want to know what did the prosecutor do and who suppressed the evidence and things like that. And what we were trying to do in terms of the fair court piece of this is explain to folks who are willing to listen that this is not just about a bad actor, a bad prosecutor, or a bad police officer. We have been litigating the case 20 years of trying to get judges to do the right thing, all in state court, except for the United States Supreme Court, all in state court, all elected judges. So we presented our forensic evidence that exonerated our client with the trial judge who was elected, and we lost. We went to the intermediate court in Alabama, 5 judges, all of them are elected. We lost. We went to Alabama Supreme Court, 9 justices, all of them are elected. We lost. And just as an aside, because we represent so many people on death row, and we're constantly, at least in the appellate courts, we're there, every day, every week, arguing and doing stuff. They're very familiar with our office and our advocacy, and we do not talk about, we don't say our clients are innocent typically. We usually focus on legal issues, and this is a case where we were saying to the courts, this client is innocent, we proved it, please take a look at this. And they just were unwilling to do it. When we finally went to the United States Supreme Court in a pretty weird procedural posture where they really weren't required, it's sort of an unusual case for them to take because the next step would have been for us to go to federal court. The United States Supreme Court took the case and reversed and said that they found a legal issue, or they agree with us on a legal issue, ineffective assistance of counsel, which was a way to get the case to be reversed and back to the trial court. It was then, when we got back to the trial court, that the prosecutor was, because we were entitled to a new trial, was forced to re-examine the forensic evidence for the first time, and our client was exonerated pretty quickly. And in terms of trying to advocate for fair courts, it's not just that a prosecutor who's now died, a bad guy who put our client on death row, did a bad thing. We've been telling elected judges about this in a very sober, serious way. We had newspaper pieces done about it, editorial pieces, and these are all judges who probably had a sense that there was an injustice in the case. And all we were asking for was a new trial. And just you just start counting the number of elected judges who just refused to do the right thing in the case when it was all there for them to see. It took the United States Supreme Court, non-elected court, to do the right thing. We go back. Everyone wants to now claim credit. The Alabama Supreme Court reversed, the Court of Appeals reversed because they were forced to, the judges wanting to get credit for being presiding over a case where an innocent person was released. But from our perspective, I think it's really important to talk about how the role of fair, or the lack of fair courts, the role of judicial elections, the role that money plays, the role that all this stuff that we know about from the data and everything, how does it affect personal lives? How does it take an innocent person, put them on death row for 30 years, and hopefully to get people to start talking about that.
Mm-hmm. So Joanna, are people talking about that? I mean, have you seen that, the report, the Skewed Justice report, does it basically indict the entire system of electing judges, or do you read it in a narrower way, and are you seeing people suggesting reforms because of the study?
Right. Well, I mean, people always ask, well, what does this mean? What's the best way to elect judges? And I was speaking with someone before the panel about this. It's not, we can certainly criticize the election system, but of course there's plenty of states where judges are appointed, and there's a lot of politics involved in the appointment process. From what I've seen with my studies I think it's a lot more about the money. And back when, in the Jacksonian era, when the state switched from a system of appointment, like the federal system, to a system of elections, because they thought that would keep politics out of elections. And they thought that was going to produce more independent judges who were not beholden to anyone when they were issuing their votes. And it's kind of funny when we look at that now, because now it seems like these election systems are all crazy and there's so much money spent, blah, blah. But to me, it's really about what the elections have become and the money, and now, of course, what we're seeing with the independent money and the TV ads. So, is it an indictment of the whole system? I think that it certainly raises concerns that the degree of politicization, the amount of money has really produced a problem. And really judges in a lot of states, and it obviously depends on the state. There could be some states like Louisiana where the voters care more about rehabilitating the existing criminals or the existing prisoners. There could be other states where there still is very much a tough on crime attitude, which we know that there is. But I think it really shows that in a lot of places, judges are having to act a lot more like politicians. Judges are not supposed to be politicians, in my mind. Judges are there to kind of protect us from the politicians, if nothing else. Now I'm getting, but they're meant to interpret the law, uphold the Constitution, represent the minority group that the majority may prefer to have a different outcome. But they're forced to start thinking about things like politicians. So we are seeing an impact. I mean, this study has had a lot of press, and then the New York Times and various news outlets. And the Supreme Court decision this year, which I think there was a panel on it yesterday, it was cited by one of the justices in their opinions. So I think that the amount of research, and not just mine, but others as well, is starting to have an impact on educating people to this problem. It's always nice for me to speak, and I think this group is one of the better educated about these issues than the groups I typically speak to. But I think it's just important. A lot of people are shocked that these sorts of TV ads air, that judges, they haven't thought about the fact that, oh yeah, judges may be influenced by this sort of thing. So, we're seeing more and more push for reform in a lot of states. And, hopefully it will become more successful as time goes on and as more of these issues get out there.
Great, thank you. I was just thinking about in the context of those of us who are sort of aware of these issues, and I don't know how many of you are from this area, but those of us who live in Montgomery County, Maryland, all of a sudden faced a retention election that became a contested election. And there was nobody I met who ever really thought about why were we electing judges in the first place in Montgomery County. And then when you realize you had to choose, there's no information on any of them. So the ability to tip an election like that is incredibly easy. Ultimately, it doesn't take a whole lot of money, and it was really kind of astounding. There was really no information except an op-ed here or there, and it was very confusing.
Yeah, unfortunately, I think I think that's the reason why the money's working, is because people aren't there isn't information. The voters don't know about these judges, and so they go in and there's 2 names on the ballot. They've barely heard of either, but they do remember that one guy supported rapists. And so he must not be the guy to vote for. And so that's really where the attack ads are, that's how they're able to influence, because there's just so little other information out there.
Exactly. But I just thought it was interesting to me because in a well, let's say it's a lawyer dense community that nobody really had paid any attention up to that point, and then at that point nobody knew what to do. So so this is a sort of a general question. They've got some great questions here from the audience. I don't know if there are any others that are going to come out, but and this sort of goes to that sort of this general discussion about criminal justice reform, the bipartisan approach to over criminalization, and this question asks, do you think the increased awareness of projects like the Innocence Project and the popularity of Serial have shifted the discussion, or are the attack ads just too strong? I don't know if any of you want to address that. I mean, is there a change? Can this greater public interest in the issues that Judge Hunter talked about in terms of rehabilitation, can that overcome the money in the attack ads?
Well, let me give a personal anecdote. It was mentioned earlier that after Katrina, Katrina devastated the public defender's office, and so you had thousands of people who were in jail without representation. We're talking about this is pretrial, not post-trial, pretrial. And so the office was devastated, and so litigation began in which some crazy judge threatened the legislature and the governor to come up with some money, or the Constitution says, I have to release these people. That was before an election year. That was in 2006, 2007. The election came up in 2008. And I guess there was some talk I would receive opposition when I ran. And I did receive opposition when I ran. But it wasn't because of that action or that litigation, because I took that as a moment, a teaching moment, to explain to people what the Constitution means. What does the Sixth Amendment mean, the right to a lawyer? And people understood it. They bought it. And so I received more positive press than I did negative press. And the only reason why I had opposition in 2008 was because it was a former prosecutor who I held in contempt of court, and I put him in jail. And I received 75% of the vote, and I think the other 25% were Republicans in the city. But anyway, so that's the only opposition I had. But it had nothing to do with the actions that I took after Katrina. Insofar as what programs with specialty courts, you now have candidates for judges who are saying, I'm going to start a reentry court, I'm going to start a drug court, I'm going to start a mental health court. And so that, at least in New Orleans, in the New Orleans area, people are accepting that and looking for that. They are looking for judges, not just to sit up there and be royal and regal. They want judges to be more involved and to be more involved in the community. That's what they're looking for. And so, I think that's a good thing. That's not to say that every judge on the bench does that, but that seems to be what people are thinking in New Orleans about what they expect from their judges.
I don't know if either of you want to address that or.
Well, I definitely think the innocence, I do think that the fair courts community and people who are advocating for fair courts should use and can use innocence cases as a way of, getting the issue in front of people's minds. I think people are always looking for the villain. When they say, okay, this guy's innocent, how did this happen? And I think a lot of times people want an individual person to blame, but I think if you can take the data and look at the political ads and say to people, this is what happens when we have a politicized judiciary, when we elect judges, these kind of things can happen. The bad cop or the bad prosecutor or something, that is a problem, but somebody allowed this to happen. Somebody, and even the Serial somebody needs to be asking, how can this, you know, if the problem was the lawyer in the case or the problem was the prosecutor, there's still a judiciary that has allowed this to happen. And so I think it's using cases where there's innocence is just an easier way of getting access to these problems. So I think it probably has had an effect.
Yeah, I mean, I would agree with that. I think that we're generally seeing a trend in the overall sentiment about how wise it is to send everyone we can to prison. And we're definitely seeing kind of a reversal on some of that. You know, I don't know from the voters' perspective. I mean, when they see an ad with a cute kid and talking about somebody as pro-child molester, I don't know how well they remember, you know, this, you know, well, on the other hand, we're trying to rehabilitate more, and we're trying to put, you know, fewer low-level offenders in prison. And so, I mean, the attack ads are certainly working, that we have very wealthy groups paying for attack ads year after year after year, and they're having an impact on who's winning elections. And so, you know, so I think obviously there's different competing interests, and hopefully the general understanding of the wisdom of some of these issues is changing.
So this next question goes to one of the ads that you showed, Joanna, the ad that was paid for by the Michigan Republican Party. And the question is do state parties get involved frequently, infrequently, in these independent expenditure campaigns, let alone attack ads?
Yeah, they do. The percentage from the political parties, about 11% of the TV ads that they run are attack ads, compared to, I think it's more like 40% for the independent groups. So every once in a while we'll see certainly an attack ad ran by a political party or even by a candidate themselves. It's just a lot more rare than it is from the independent groups. And even, you know, with the independent groups, it's interesting. For those of you who are probably familiar with the Caperton v. Massey case, which went to the Supreme Court about the, you know, appearance of bias and recusal and that sort of thing, the Massey Coal Company, which ran ads under the name of their group, which was called "And for the Sake of Children," and no one can argue with that. We're all hopefully pro-children, but you know, so we see these groups create these, you know, the entities that are running these, and often it's under a title that we can't really disagree with. So I would say the political parties are certainly involved. It depends on the state to the degree to which they do get involved and the degree to which they are willing to run these kinds of ads, but they certainly don't do it anywhere near as frequently as the independent groups.
So this is kind of combines a number of the themes that we've heard about, but it would be interesting, I don't know, Joanna, if you've seen the private prison industry involved in running ads, or Judge Hunter, if you have private prisons in Louisiana, is there pressure there in the political system, campaign donations or attack ads that sort of add to the pressures to put more people away?
Not really in Louisiana, but we have private prisons in Louisiana, but we also have local sheriffs who are now, I would say, keeping the bulk of state prisoners in Louisiana. So now the DOC is paying the local sheriffs to keep those prisoners, and of course the local sheriffs love it, you know. And many of those local sheriffs are not providing any GED, skill training, or rehabilitation services at all, because it goes against their business model, you know, because it's in their interest that someone gets released after 2, 3, or 5 years and re-offends, which means that person's coming back. So you know how now to budget, you know. So that is a serious problem that we have in Louisiana, where now the State Department of Corrections is sort of getting out of the business, but now they just shifted it to the local sheriffs. And so that's a problem. And that's why you have, you know, in Louisiana before, our marijuana laws are crazy in Louisiana. The sentencing. Your first offense is a misdemeanor, 0 to 6 months. Your second offense conviction is 0 to 5 years. Your third or fourth offense is 0 to 20 years for smoking weed in Louisiana, for being in possession. You can get that. When there was reform to deal with the sentencing aspect of the marijuana laws, the sheriffs and the district attorney's office came out against it. But just recently, they decided to come together, so now they've reduced the sentencing schemes. Your first offense, your second offense, well, your first offense is still a misdemeanor. Your second offense, I think, can still be a misdemeanor. Your third offense now is 0 to 2 years, and your third or fourth offense is 0 to 8 years. So that's what the sheriffs and the district attorney's office and the reform advocates coming together. But, you know, the Sheriff's Association and the District Attorney's Association in Louisiana are very strong. And if those guys would come more on board to deal with, you know, what do you do with that person before they're released, and so you can have some positive factor after they're released, I think Louisiana can be a leader in criminal justice reform regarding sentencing and post-conviction issues. But, you know, we're getting there, hopefully we get in there.
So Joanna, I don't know if you want to speak to that.
So that's a really interesting question, whoever asked that. And given that every state and the federal system now contracts with private prisons, we know they give substantially to congressional races. So I don't know specifically that they've given to judicial elections, but I can't imagine that they haven't, given how much money they've been spending in other sort of political races. You know, but that does raise an interesting point, and something I didn't say, which was most of the groups, obviously the private prison systems have a very specific interest in criminal justice issues, and hopefully, from their perspective, hopefully sending more people to prison for longer. But most of the groups running these ads don't care at all about criminal justice issues. It's like the Wisconsin Manufacturers Association, the Chamber runs a lot of these. They care about largely business issues. The voters don't care about business issues, so there's a judge who they don't like his rulings in business cases, and they just find a criminal case which kind of suits their needs for the TV ad. And so, while there certainly could be a couple of groups, private prisons as well, who are contributing because they actually care about the criminal justice issues, that's not the majority of who's paying for these ads.
Mm-hmm. Well, it's the subterfuge, right? Like the Caperton case.
Yeah.
So this was a really good question for Randy. Any chance that the Supreme Court will review Alabama's practice of judges overriding juries to impose the death penalty?
It's a painful question, a very good question. The hopeful side of me is thinking they have a case out of Florida right now where they're dealing with part of the sentencing scheme in a death penalty case. And my hope, irrational hope, is that they're going to do something about judicial override in that case. We had this past term 2 cases where both of our clients had jury verdicts of life without parole, and judge overrode, and coincidentally, they were affirmed on the same day by the Alabama Supreme Court, so we were able to file cert petitions at the United States Supreme Court on the very same day, and we cross-referenced the 2 cases because they basically revealed the classic case of arbitrariness. We had one case where the judge basically said, I'm overriding because the victim's family, it didn't say it in so many words, but is basically asking for the death penalty, and the jury did not hear all the testimony about how the victim's family is suffering because of this crime, and so therefore I'm overriding, I'm going to discount what the jury said. In another part of the state, we had a client, she was convicted of setting a fire to her house and killing a disabled son of hers, and the husband and his family and our client's family all supported our client, believed that she didn't commit the crime, believed that even if the fire had started, it was an accident. At the sentencing, begged the judge to at least sentence her to life without parole. She'd already been convicted of capital murder, and the judge was provoked and basically said, because no one's standing up for the victim, this poor disabled son of hers who died in the fire, I feel compelled to override the jury's verdict in this case. And so we were able to go to the United States Supreme Court and say, if you were looking for arbitrariness, if you're looking for an opportunity to deal with this, we have 2 people affirmed on the same day. One is on death row because the victims wanted the death penalty, and one is on death row because the victims didn't want the death penalty. coincided with last term, Justice Sotomayor dissenting from denial of cert on this issue, where she basically said, I think override is unconstitutional, and signaling, we thought, the court is ready to address this issue. We got decent amount of media coverage. It was not something that slipped through the cracks at the court, and they just denied cert. So they don't seem to be interested. We thought Sotomayor's dissent last term was an invitation to address this issue. I'm now thinking that maybe it was her way of saying, we're not going to grant cert, but I want to speak my piece. I think it's unconstitutional, so I think we have one vote on the court. But we were very, very, very hopeful that they would at least address this issue. In particular, because override is really the essence of like the problem with unfair courts and with politics and courts. It just reveals everything that's wrong with electing judges.
So there's a question that sort of follows on, but maybe the answer is we can't quite make this argument yet, whether elected state courts are unconstitutional completely. And maybe the data, in terms of how unfair they are to criminal defendants and the growing influence of money, maybe that'll start helping us make the case that they are just so arbitrary, as you said.
Well, we think they're arbitrary. Your report points out that Sotomayor said, she's concluding that they're succumbing to political pressure. So, I mean, she's basically completely bought into the idea that these ads are forcing people to make decisions that they otherwise wouldn't make.
And maybe Williams U. Lee kind of helps lay the groundwork for that?
Yeah, I mean, unfortunately, I think we're a long way out, and we'd have to talk to a real con law expert to really understand all of the constitutionality arguments. But yeah, I mean, hopefully Williams U. Lee is the first step we've seen in a decade in the right direction. So, hopefully we're not too far away from heading that direction.
So here's
there is a quote, and I can't remember which case it is. It might be Minnesota v. White, back in it was that 2002, I think, where some of the judges, in their opinion, said that, how did they phrase it? I mean, this is a little bit wrong, but something about, this is kind of what you get when you elect your judges, but the Constitution doesn't prevent states from doing stupid things. And I think there was actually the word stupid in the quote. So,
well, unfortunately, I guess that's true about many things that states do. This question asks, spending in state Supreme Court elections reached about $56 million in 2011 to 2012. The blowout governor's race in Ohio in 2014 cost around $30 million. Given state courts' wide range of subjects covered, why isn't there more spending?
well, I think that part of it is, I would say two things. One is how much money is needed to influence the voters. That's a big part of it. And so with a gubernatorial race, people generally have a little bit more information about the governor. And so it's going to take a lot more money to, sway people, influence people, whatever. With the judicial election, the majority of voters come into the voting booth, even very, very educated people, probably a lot of you in this room, myself included, go into the voting booth and have never even heard of these people. Especially, maybe this is state Supreme Court we have, but not really the appellate court judges, the intermediate appellate court judges. And so it doesn't take as much money to get the information out there. That being said, we're seeing more and more money spent, and so I don't think for long we'll be saying, why is there so little money spent in these races?
Yeah. So we are coming to the close. We have very little time, so I'm sorry I'm not going to be able to get to all these great questions. But I do want to ask this as a final question, and we'll see if the panelists have any concluding remarks. But this is a very interesting idea, maybe for a future study, but maybe Joanna or Randy or Judge Hunter, about this. But is someone studying re-election patterns of judges who've sentenced to rehabilitation or reentry programs as opposed to giving harsh sentences?
No, but as I said earlier, it is a good campaign piece when you run for re-election. I can attest to that. But everyone is jumping on the electoral system, and but you have appointed judges who are very conservative as well, also, and another aspect of the electoral system I don't think you would have as many African American, Latino, or female judges if it wasn't for the electoral system in those communities, especially where if the city is majority African American, majority Latino, what have you. But I think at the end of the day, it's about what kind of judge are you, and we're also supposed to be fair, whether we have to be elected or appointed. And that's not to discredit what Joanna and Randy are saying. There are, especially on the Supreme Court level, we have a lot of money coming in. And they're coming in not for the criminal, as Joanna said, not for the criminal decisions necessarily that the judge made, but even though they use that, but it's all about money. And it's all about those business interests. And it is using that one case against that judge. So it's not really about criminal. So how do you educate the public with that? Well, unfortunately, because you are an elected official as a judge, you have to fight that. You have to deal with that with your campaign, which means you have to go out there and raise money as well. Maybe not as much as those outside interests, but you have to go out there and actually campaign to get the money to run your campaign to get the facts out there about what kind of judge you are, why you made that decision, and what have you. So, even though Janice said we're not supposed to be politicians, but unfortunately, you have to go out there and raise money for your campaign. And to get your story out, or I don't want to say story since what I saw yesterday, but get the truth out about why you made a decision. And I do believe that if judges would educate the public as to why they made a decision, I think that would go a long way. I think that's what has allowed me to stay on the bench for this long, because every time I made a controversial decision, I always gave reasons for it. And I make sure that the media receive those reasons as well, so that people won't be left guessing as to why a judge ruled the way they did. And I always saw them as teachable moments, because most people don't know about the Constitution. Most people don't know about being in court unless it's affecting them or their family members, and that's not with most people. So, that's what I've tried to do.
Well, thank you, and I think you just, I think gave us a nice closing in terms of why state courts matter, because most people's exposure is there, where 90% of our cases in this country are coming from the state courts. It's where people have family matters decided, and their livelihood may be affected. And so, it's clearly a testament to the importance of the issue. And thank you to this group of people who have engaged on such a critical matter. So we are out of time. I am sorry about not being able to get to all these questions, but can we give our panelists a round of applause?
Carolyn, thanks so much for moderating, and to all of our panelists. This is really terrific. And I think what's so terrific about this panel, and all of our sessions, I think, are so interesting. And this one, some of the things we've talked about is the hard data, the evidence of the problem, stories of real people, how to put a human face on it. Judge Hunter, when you started with the people's names and what they do now compared to what you can imagine they just would never have had the opportunity to do without this kind of problem. And early in my career, I represented people at the Whitman Walker Clinic in legal services. So many of my clients were recently released with, I'm going to call them this, faux reentry plans, and because they had HIV, they dumped them out on the street in the middle of the night, and so there were some issues related to that we spent a lot of time on. But the idea that they could have had kind of a complete education and a trade to go to, a lot of them, they went back to drugs and crime because they had no other choice, right? This is a totally different way. I've learned so much from this session, so thanks. Where we're headed now, 15-minute break, and then into breakout sessions, all on this level. Today, for everybody who was here yesterday, we were upstairs too, but advocacy track, diversity track, state issue track, there's a session for each of those. One of them is right here in this room, but in the meanwhile, I think we have a coffee break out there. In 15 minutes, we'll come back, and thanks again to our panelists.